Finally, we have the third branch of government, the judiciary, right? The judicial branch. If Congress, the legislature, makes the laws and the president, the executive, enforces the laws or executes the laws, the judiciary then actually interprets the laws, right? They tell us, in Justice Marshall's words, what the law is. Now, Marshall said this in his decision in the case Marbury versus Madison. And Marbury versus Madison is an incredibly important case because it established the principle of judicial review. While it seems clear from Hamilton's Federalist Papers that judicial review was intended as a power of the judiciary, it was not explicitly written in the Constitution. And Marshall, in the case of Marbury versus Madison, actually established this power. Now, the court, before we return to the ideas of the power of the court structure is a dual court system, right? There's the state courts, and then there's the federal court system. And the federal court system is what we're concerned with. There's the district courts at the bottom, then the circuit courts of appeal, then all the way up the top is the Supreme Court. The Supreme Court currently has 9 justices, and they have to hear every case that is argued in front of the Supreme Court. This means, of course, that they can't hear very many cases a year. It's usually only about 100. So about 1% of the cases that are actually appealed to the court. So how do they determine what cases to hear? Well, from a very practical standpoint, we determine it by the rule of 4. If 4 justices agree to hear the case, they will all hear the case. But what makes those 4, or potentially more, agree to hear a case? Typically, cases must have some outstanding point of law. That is to say, something that is unresolved, something that needs interpretation. If the issue at hand is something that the court's already ruled on and they don't feel like changing that ruling, they'll just tell the lower courts, yes, you decided this case properly based on precedent, or based on precedent, you didn't decide this case properly, and you need to reconsider it in light of these particular rulings that we issued. So, the court limits what they hear to cases that they consider to be on important issues. And we know that there have been different eras of the court, right? So different issues seem to interest the court at different times, presumably based on what is going on in the public. So there were issues of basically federalism, federal and state relationships for many years until the Civil War basically resolved them all. There just weren't really many cases coming to the court anymore. Now, the judges on the court have lifetime tenure, right? That means that once they are appointed, and they're not elected, they are appointed. Once they are appointed, they serve for life. This applies to all federal judges. Now, why do they have lifetime tenure? Because we don't necessarily want the people interpreting the law to be too beholden to the people. We don't necessarily want them to be delegates, right? Because we want to make sure that the people interpreting the law do so without necessarily paying any attention to what the public wants, but rather to what the law says. Now, we know that this is not exactly how it happens, right? Judges are people, and they are appointed by presidents who have clear political ideologies. So we know that judges do impart their own ideology onto cases. But they don't, and we know, and we know that the court does to some extent consider political opinion. Right? I gave the example in class of Brown versus Board of Education that the phrase all deliberate speed was put in there because they knew public opinion was not going to support immediate desegregation of schools. Now, this points to a weakness, if public opinion wasn't going to support desegregation, why did that matter to the court? Well, it mattered because the court cannot enforce their own rulings. They do depend on the political branches, the executive and the legislature, to enforce rulings. So, if a ruling is too unpopular, the political branches won't want to enforce it because they do have to act as delegates. It's also possible, as was the case with Jackson, that the political branches just don't want to enforce it and they ignore it altogether. That is why Justice Marshall created the idea of judicial review, because in the case Marbury versus Madison, he was concerned that the president would just completely ignore any Supreme Court ruling giving Marbury his commission, forcing Madison to deliver it. So rather than issue a ruling that they knew would never be obeyed, they chose not to issue it. And in doing so, Marshall is very clever. He created this power for the court, right? This power of judicial review. And that, of course, is one way they overcome their weaknesses. They might be very weak because we don't want unelected people serving full life tenures to be too powerful. That kind of sounds like a king then. But we can't, so we weakened them, right? The court is constructed in a way that weakens these judges. They have very little power to initiate action, right? They must wait for cases to come to them. So if a judge thinks they want to change a ruling, they just got named to the court, there's this old ruling that they hated and they've always wanted to issue a ruling that would reverse it, they have to wait for the right case to come to them that would allow them to do this. They can't just go out and look for it. Now, they also, right, don't have enforcement power. There are other weaknesses that we have discussed as well. Now, how have they overcome the weaknesses? Obviously, judicial review, but also the system of delegation, right? Rules that say how precedent should be upheld. Rules that say once the Supreme Court has issued a ruling, the only institution that can overturn that ruling is the Supreme Court. Unless, of course, Congress wants to write a constitutional amendment to change what the Constitution says, the Supreme Court is the final word on what the Constitution says. So that can be a strength. And certainly setting that standard, the this is the law standard, can help them, can help them overcome their weaknesses, right? And they set this law, right, by things like delegation, by requiring lower courts to follow upper court rulings. Again, these are not the only strengths and weaknesses of the court, and you may want to go and look back at your notes from our lecture on the judiciary, as well as the textbook, to identify further strengths and weaknesses. Now, one of the court's jobs in deciding what the law is to determine what protections we have from and by the government. So protections by the government are our civil rights. These are things that the government has to provide to us. Typically, they are associated with the government actively providing protection for minorities. That's why the civil rights movement, obviously, was the movement for African American rights in the 60s. Now, these again are protections by the government. What rights do we have? Where are they written? Well, for the most part, you should go back and look at the Bill of Rights and look for things where it says the government will provide something